Who is that cat?
Archer.
You're just gonna stare at me?
Oh.
And walrus. What the hell? Cringe.
Hello, everybody. It is Artie of Artie's Corporate Fiction. How you guys doing? Happy Sunday. Today's the day where I get to have a discussion with Brandon Joe Williams. I did see that he was live earlier. But I think he's having some issues of okay. Yeah. But we'll see if this is actually happening. I did do a little bit of background work preparing for this. Who knows if I'm gonna need it, but yeah. In the meantime, sorry. I think he's he was trying to do like a live stream collab like internally. Hey Mike, I see ya. What's going on? Through YouTube, but that's a little bit more complicated versus somebody who's doing it via OBS or another streaming platform. I did get a message from him, so we're gonna see if those work here in a bit. Oh wait, sorry, Windows. The nature of the discussion is going to be on the definition of person and the differences and distinctions between a state citizen and a federal citizen. I'm waiting for him to send a link to a platform called Riverside. I don't know if you guys have heard of it. I've never heard of it, but what am I supposed to fix, Wonder? Okay. sweater that you forgot. I have to fix that later. All right. Good enough. The last time I debated with somebody was Paul Unslaved. Wow. Well, there is a cat over here. Savannah. What? Savannah, come here. Come here, baby. Come here. Come on, uppies. You want uppies? Come here. Waiting for him. You guys can enjoy Serana in the meantime. Hmm? Serana, say hi. Serana, say hi. No? Okay. Hmm? No, Mike, I just saw your Twitch message. You didn't wake me up from the DM this morning. I just thought it was weird that you just sent it to me like at 4:45 in the morning. Hmm? And now she's using the top of my new PC as uh a warming spot. So, of course. Hold on. Why is my mouse suddenly not working? What is happening? There's my eek in the background. So now you guys got to see both of them. Why is my mic acting, or excuse me, not my mic, my mouse acting up? Um, hmm. Okay, there we go. Much better. Alexander, I did get a message from him. We're supposedly trying to do this on a different like live streaming platform. Um, I don't know if it's going to be on YouTube on y'all's end. I know that I will be able to stream it on my end, but I'm still waiting for his message here. So the Cowboys won against the Jets, so that's not really something to write home about. I mean, if we didn't beat the Jets, then that would just tell me that the Cowboys are performing even worse than I expected this season. But yeah, I got to hang out with my brother and the family. The baby came by. Like I said, she forgot her little sweater. It was fun. It was nice. Oh, I also got my e-bike, and it is a lot of fun. It's really cool. It's heavy though. It's a heavy boy. But I know that my apartment's parking garage does have a bike rack. So as soon as I get my lock, which is coming in tomorrow, I'll be parking that in the bike rack instead of in my freaking apartment. And the battery's removable too, which is a good thing for sure. Ooh, nothing yet from him. I got my phone up here. Urana, what do you want, baby? What's up, OGA? Let me see if I can have some background music while we wait, I guess. Or not. Some nice lo-fi beats. Brandon's trying to work on getting us live here. Oh, there he is. He's live. What's good, buddy?
It says live. Okay, I think everything's pretty good. We're just gonna wait for Sam.
What do you mean, wait for me?
I think we're doing okay here. The last show that we did, the last stream, I think was 250 people or something were in it. And this one we're already at 190. And then there's a chat here. Let me see if I can get into this chat. Oh, here we go. Hi, guys. I see the chat. Okay, here we go. I see the chat, guys. Thanks. Nice haircut. Okay. Thank you. Let's see here. We got hand waving. Okay.
Has this guy really never been
Rubies.
on a live stream?
No, I fucked up, guys. I fucked up. So give Sam a minute because I couldn't figure out the YouTube live thing on the other stream. So I had to make this thing on Riverside. And then I connected it. I said, fuck it. I connected it to like X and YouTube and Facebook. So for a lot of people, this is like the first time I've ever done anything like this, and they're going to get like a thing, and it's going to pop up and say, "Oh my God, he's live!" So that might be why there's already 200 people, almost 200 people in here. But we're going to just give this a second and wait for Sam to get in here. We need a few minutes, anyways.
He said he sent me a link to the invite. I haven't received it. I don't know where I'm supposed to look to receive it.
But to X, Facebook. and what? YouTube. Okay, he's finding it. He's finding it. He's finding it. 227 people in here. Wow, this is cool. I've never done this before. Maybe we'll do more of these if you know, the Riverside thing, just so you guys know, the chat box is fucking awful. I can only see like 3 comments at a time. So
There's a double mic. What the hell?
yeah, I don't know. It's not going to be great, but
how about
just know I
does
can
this
only
work?
see like 3 comments, and I'm
well,
gonna try to figure that out
1,
right now.
2, 3,
It's
4,
pretty
5.
cool though.
Okay.
Hey, Sonny's here. What's up, Sonny?
Um, okay. Okay, he said he sent it to me by email. All right, hold on. Oh, I don't want you guys to see these things. We're almost there. I think we're finally getting this together. Hello,
It's
hello.
annoying. It's really annoying. Hey, there he is. Yo, what's up, dude?
Hey, finally got this
Sweet, we're in
working.
business. Yeah, sorry about that. I just gave up on the YouTube thing. I know you're more familiar with it. I am not.
Right. So, like, whenever I do discussions like this, you don't really rely on YouTube directly to have a connection. You usually rely on an external platform like this, or StreamYard, or
Okay.
Discord, to connect with each other, and then you can go live and then broadcast that face-to-face discussion. So that's usually how I do it.
The only problem left is just I keep getting these stupid notifications saying that people are joining in portrait orientation. That's
Yeah, that is happening.
You're seeing that too?
Yeah, you're vertical, and so am I.
I don't know if I can fix that one. I think this is as good as it's going to get, which is pretty good. Can you see the chat on the right hand side? You should be able to see the chat. I don't know if you're in.
Let me see here.
It's kind of shitty. On
I
this
see
platform.
the chat.
You can only see like
I think.
4 comments. I did full screen, so I can see like 4 maximum.
Okay,
at
I
a
do
time.
see the chat there.
It tells you what platform they're on, which is kind of cool. It says YouTube. Straight up Duder 258 now. Douche Art Y. The Pickle Juice Jew. Welcome to my audience. So give me a second. I'm going to step away for just a second, grab a drink, and I'll be right back. And then by then, I'll be ready to rock. We should have, well, geez, it looks like over 300 people. And then we'll just get rolling, even though these notifications are really annoying. But I don't know what to do with that. So give me 2 minutes, guys.
All right, I'm trying to figure out the I can turn off the camera while recording, but I can't switch. Okay, I want to stop recording. All right, hold on. I want to shut up. Oh my god. Nope. Hold on. No, stop. Piece of shit.
Did Artie step out? Oh, there he is. He's back.
Can you hear me?
Yes.
Yeah, I'll be right back. I'm trying to switch my camera, so it's just me that's showing. I'm trying to work
No
with
problem.
that.
No rush. It's okay. Be great if we could figure out how to get these notifications off of here. Let's see if we can figure that out while he's doing that. We're close, guys. And next time I won't have to go through all this horse shit. Let's
Oh my fucking god. Hold on. Okay, you guys can see the little me. I'm trying so that you guys can see this. Okay. Okay, I think I got everything sorted here.
Sweet. Yeah, I'm just trying to figure out how to turn off those notifications. But I don't think it's possible. So I apologize. You're going to have lots of notifications. But anyways, welcome, everybody. This is it. This is the official start. We'll just start here. And let me just close out these extra windows. Close everything out so we can get started. And perfect. Okay, guys. Perfect, man. Welcome to the show. This is going to be exciting. My first question is, is your name Sam or is it Artie?
My first name is Sam, but I go by Artie as part of the channel.
So do you prefer Artie over Sam? Is that correct?
Basically, yeah.
Okay, perfect. So that's good to know. Couldn't figure that out. And then Great. So how I want to start this is, if you don't mind, I'd like to just kind of for you to give like a little background of you, when you started in law, when you went to school, when you got your bar license, and then also kind of some of the cases you've worked on in the past, and then some that you're working on now. Just like a kind of a bird's eye down overview. It doesn't need to be too brief. I mean, with enough detail to actually know your background and what you do and kind of who you are, if you wouldn't mind.
I mean, sure. I went to law school in 2007, got my license in 2010 for New York and New Jersey. I've been working in New Jersey for like the last 15 years until this year, where I was able to get my license in Texas. And then I've since moved to Texas with a new position. A lot of the work that I've done is working in regulatory compliance, kind of boring stuff. But now with my new position, I'm more often in court itself. And so when it comes to sovereigns and sovereign citizens, that's not like something that I focus on as part of my professional practice. It's something more of like something as I've had an interest in outside of the profession as like a personal hobby.
Okay. And you used to do regulatory compliance. That would be in what arena, what area of regulatory compliance?
For the longest time, it was with public records access in New Jersey. So that's the primary field.
So it'd be like the state's version of a FOIA request, like that kind of thing?
Yeah, basically.
Okay. And okay, so were you working for the state, like pulling up documents and giving documents to people, or figuring out why they should or shouldn't have said documents that are requested via state version of a FOIA? Is that what it was?
No, that I didn't work on that specifically. But I mean that was not what's I didn't work on actual like records requests per se. It was more about the law in general and how it's being applied at the state level.
Within the confines of the arena of information and information releasing?
Correct.
Okay. I think I'm tracking with that. Okay. And then now you are in the courts more often. Now, regulatory, it doesn't sound like you were ever really in the court. That's just paper, right? Basically?
Right.
Okay. And then now, what are you doing now? Now, this new thing in Texas where you're in the courts, what field or area are you working in now?
I mean, I'd rather not go into further detail about my profession, if you don't mind.
Okay. Can you give us at least a general idea as to what the field is? Like, even if it's just like one word, like immigration or whatever, or like criminal or something.
I mean, I'd rather like keep it as it is right now.
Okay. No problem. I don't want to make it uncomfortable.
The nature of the internet can be weird sometimes. I think you understand
no problem. No problem. So, can you say at least civil or criminal? Can you at least go that far?
No, I'd rather keep it vague.
Okay.
If you don't mind.
Okay, no problem. No problem. So, okay, have you ever worked privately or for any sort of private practice, or have you ever had your own practice in any way or taken on private clients?
I've worked in private practice before, but then I kind of have to ask you, why are you asking me these questions? I thought we were having a discussion about U.S. citizen versus state citizen. I don't understand why you're...
It's just to understand you. I mean, I don't, the whole point of this whole thing is that we have somebody who's a licensed attorney and somebody who's not, somebody who's just this fucking goofball weirdo on the internet. So establishing...
You're not like a goofball on the internet. You're trying to advertise legal knowledge for people to actually use in practice, are you not?
I don't use the word practice, but yeah, essentially. The word practice is a legal term.
So you're trying to convey your knowledge to other people who are ostensibly paying for your services, right?
Well, they're all donations. They're legally
Donations,
classified
tips.
as donations.
Sure.
So there's no actual contract in terms of how you'd think a contract. But beyond that, yes.
Right. So I feel like you don't you
There's
shouldn't
no
belittle
legal
yourself.
obligation inside of the trustee beneficiary relationships that I create. There's no contractual relationship. It's more of a fiduciary relationship, I suppose, than a contractual relationship because it is a donation.
Right, but I do you not feel obligated to act on their behalf if they give you a donation for a certain service?
Yes.
Okay. So, like I said, you say you're like just a goofball on the internet, but in reality, you are, in fact, offering services to people. Whether or not it's in the form of donations that you receive, you are offering services to people, as part of your conveying your legal knowledge.
Yeah, that's correct. I guess the reason why I'm asking all the questions is just to establish kind of like your background, who you are, what you are, because people are going to want to know that. Like, who is this guy? He's debating Brandon J. Williams. Like, what's his background? What does he do? And it sounds like, you know, a lot of your history is mainly in governmental type area. So I just
Sure.
that's all. Just wanted to
And-
establish that. There's not much more to it. I mean, that's all.
Okay.
So I guess from here, yeah, we can just go ahead and get started. I just wanted to say, you know, I've seen a bunch of your videos. I did see the video that you did in prep for this show,
Mm-hmm.
and the reason why I decided to kind of debate you, because I get offers for a lot of debates, is because, you know, you've been doing this kind of stuff and talking about this stuff for quite some time. How long have you had your channel for?
This particular channel since 2019.
Yeah, so it's been, you know, 6 years you've been doing this. Okay, perfect. So yeah, so I guess that's enough to just kind of roll into it. I want to go ahead and today we're going to be talking about the differences between state and federal U.S. citizenship, what that means, and does it even exist, I guess is really where we're going to go with this, because I already saw your live where you were making the notes for your audience. So I'll just do a screen share on my end, and then what I like to do is just kind of go section by section. Originally, I was gonna use the treatise on the word person, which we can't use, but I have all those same quotes over here. So I'm rewriting an Army training manual from 1928. It's called TM 2025. It was released by the Army, and it was used in the Army between the years of 1928 and 1932. And I'm rewriting it and modernizing it, essentially, which I'm not going to get into what that means, but all the details is what that means at the top of the screen. It has all the same information and all the same quotes and everything, but there's also a ton of intermediary information that I've added to it that I would rather use, but most of it is the same as what you read in the treatise.
Right. So I think a fundamental a foundation of this entire discussion is going to be on identifying not just what a state citizen and a U.S. citizen is, but also the nature of what is an individual, what is a person, what is people. Because I feel like that serves as the foundation for all of your arguments coming after that. So, I mean, the first question I would have is, while I understand that your treatise cites multiple different federal statutes when it comes to defining person, are you using the immigration definition as like the fundamental one?
For the federal citizen side of the equation, yes, because if you go to, for example, 8 USC 1101, most people think that this has to do with citizenship, which it doesn't. It has to do with aliens and nationality. The definition of Title 8 is aliens and nationality. You don't even see citizenship really in Title 8.
Title 8 deals with immigration specifically.
Well, yeah, but no, because it deals with U.S. citizens and non-citizen nationals under subsection A22. It has both.
Well, it defines who U.S. citizens and non-citizen nationals, for sure. Correct. And then, yes, it'll subsection of the of Title 8 talks about the naturalization process. So, of course, they're going to define what a U.S. citizen is.
Yeah, it's part of that, but it had. I mean, where else would it be? I guess would be my question to you. Like, where else would it be?
Well, I feel like you pointed out in your treatise there are multiple different parts of the U.S. code that defines person.
Yes, and the reason why I'm using this definition of the word person is because, as far as I'm concerned, it's the best and closest thing, at least, to anything that would be involved in citizenship, because you have to have nationality first before you can have citizenship, which is really obvious looking at subsection A22. The term national of the United States means A, a citizen of the United States, or B, a person who, though not a citizen of the United States, owes permanent allegiance to the United States. So
Right,
this proves that a person can have nationality without citizenship.
right.
But the thing is, a person can't have citizenship.
To the people of Guam, not Guam, but American Samoa.
No, I understand that. But I'm just saying it is what it is. You can have it is possible to have nationality without having citizenship, but you can't
Yes, but
have
that is a
citizenship.
very, very tiny portion of the American population.
I don't disagree with you, but I'm just
Okay.
saying it is what it is. I'm not saying anything more than that. It is what it is. It is. You can have nationality without citizenship, but
Okay.
you can't have citizenship without nationality. So nationality is the first tier, and then the second tier after nationality has been established is citizenship. That's all I'm saying. So you're saying, why are you using this definition? I'm saying because I don't know of anything that would be a better spot to use this information from. If there is a better spot to use this information from, then by all means, tell
Well,
us.
I guess my contention is that if I am to understand your treatise, is that the classification of a state citizen is one that is of a more preferable classification than a U.S. citizen. Do I have that correct?
It depends. It depends on how you look at it. It's preferable if you meet the requirements to be one. I think so. I suppose there is some subjectivity to it, but I think
Okay.
objectively, I would say yes.
Okay, so then if that's the case, then why not use the state's definition of person instead of the feds? It's because if the federal constitution and anything deriving from that is reserved for U.S. citizens, why bother relying on the fed's definition of person instead of the state?
Well, no, a state citizen still has access to all the federal protections. There was a federal government and there was federal aspects in the federal constitution prior to the advent of the U.S. citizen category.
But there was also state constitution, correct?
Yes, of course.
So then what would be the point of the federal constitution if the state constitutions are supposed to protect those rights for the state citizens?
Well, that's the whole point of the dual nature of America. That's been the arguments in the courts since literally John Marshall's time period. I mean, that's always been the argument. There's two entirely different systems. The thing that makes it so complex, which I wanted to get into with you, is the fact that there's two different governments. There's one that runs underneath all of the states as a union, and then there's an entirely separate government under the District of Columbia and all of its possessions, which would be the U.S. territories and insular possessions. That secondary class, which essentially the way they describe it a lot in the Supreme Court is, under Congress, that second class didn't have its own citizenship class until the U.S. citizen category was created. So it didn't have its own citizens. So in today's world, we have two different worlds, two different governments, both with their own citizens. But prior to the advent of the U.S. citizen category, the Congress did not have a citizenship class.
Well, I don't know if I can agree with that, because if you go to the Naturalization Act of 1790, I mean, the first paragraph talks about how somebody is to become a citizen, but that first paragraph does not say anything about this is the way in which you're eligible to be a state citizen of whatever state you're residing. It's to be a citizen of the United States.
Yeah, that comes from the Constitution. I forget exactly where that is. Let me see if I can find that.
So then a U.S. citizen has absolutely been in existence since the nation's founding.
Yeah, but the definition was completely different, which is actually covered by Mr. Miller in the slaughterhouse cases. But give me 1 second. Where in the Constitution does it talk about how citizenship is of one of the several states. The citizens of each state shall be entitled to all privileges and immunities of citizens in the several states, this is a lot of what they were talking about in when they were which I want to go over with you today. This is a lot of what the guys a lot of what Senate and the House of Representatives were talking about when they were presenting the 14th Amendment to be approved. They were talking a lot about this and stuff like that, which I actually just recently, yesterday, just added all that information in. I found all the original quotes from the various people who were talking about all this, and I put it into. I didn't put it in the treatise. I put it in this one because this is actually going to get made into a book. So let's just start at the beginning. I kind of wanted to just start at the beginning and walk through an entire timeline with you, all the way to the The first thing I wanted to cover was the preamble of the Constitution, right? In the preamble, it says "we the people," and you can agree with that, right? We the people, right? And the word "people" is capitalized. There's a bunch of different random capital words, like the word "union."
Right.
In most Supreme Court cases, is capitalized throughout all the 1800s. So that's actually a capitalized word. The word "people" is capitalized. Whatever, right? And then we have the slave trade clause on the U.S.
And
Constitution.
it has persons. I understand your.
Well,
I
I just
understand
want
what
to
you're
go.
saying here.
This is not
again.
I'm
You're
not,
trying to delineate a distinction between people and persons.
Hold on now. Slow down.
No,
it's not me. It's not me doing this. I don't want you to say it's me doing this. Who's doing this?
You. This is your interpretation.
No, it's not. Whose interpretation is it? It's not mine.
Yours.
No, it's not. It's not mine. Whose is it? I'm asking you. Whose is it?
It's yours.
Not mine.
I'm saying it's yours. You can say I'm wrong, but I'm saying it's yours.
No,
you can tell me who it is.
It's the fifth Chief Justice of the United States, Roger B. Taney.
Are you sure about that?
100%, which we're going to cover all the quotes.
Wait, Taney was the author of Dred Scott, correct?
That's correct.
And you're aware that that's been overturned, correct, by virtue of the 14th
the slaughterhouse
Amendment.
Cases. Yes.
Right. And so you also understand that, therefore, the distinctions that you can delineate from Dred Scott doesn't really apply anymore?
No, because all the stuff that's in Dred Scott is all talked about and it is all related. Everything
was discussed. It was discussed, and then the author of Dred Scott, Miller, effectively said that Dred Scott doesn't apply anymore by virtue of the 14th Amendment.
Well, it's by virtue of slaughterhouse cases, and the 14th Amendment both, but it wasn't really clear until the slaughterhouse cases. But yes.
Right. So then, as a result of the slaughterhouse cases, it effectively said that persons are all one.
No, that's
the 14th
not what it
Amendment
says
was
at all.
Yes, it does.
No, we're going to cover that in great detail. We're going to cover all of the Civil Rights Act of 1866. We're going to cover all of the quotes that people were saying when they were presenting the 14th Amendment to Congress. We're going to go over all of it. I've got everything here. I've got such an extensive library that we're going to go through, and I want to go through it, but I want to go through it on a timeline. I want to go through it by date because I want to build the whole story by date. I don't want to jump around. Do you know what I mean?
But I think the problem is that you want me to walk along your framework, but I have a disagreement on your entire framework here. I understand you want to build this up to this conclusion that people means white people, persons means freed African slaves. I mean, we could
persons means non-white. It's more than that. It's non-whites. The Mr. Miller is clear about that in slaughterhouse cases. It includes all non-whites
and white people.
No, it does not include white people. You can see that even on the first line of the Civil Rights Act of 1866. You can see it's very, very clear. Be it enacted that all persons in the United States and not subject to any foreign power, excluding Indians not taxed, are hereby declared to be citizens of the United States, and such citizens
of every race
and
color.
Race
How
and
does
color,
that not include white people?
You'll see. without
Okay.
regard to any previous condition of slavery or involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, shall have the same right in every state and territory in the United States to make and enforce contracts, to sue, be parties, give evidence, inherit, purchase, lease, sell, hold, and convey real and personal property, and to full and equal benefit of all laws and proceedings for the security of person and property, as is enjoyed by white citizens.
So then white people are already U.S. citizens.
Yeah, but the definition of what that meant prior to this point is it meant a citizen of a state.
No.
And you can see that even in Bradwell v. State, which happened the day after Slaughterhouse. He's still talking about the state citizen category.
No. What the 14th Amendment did is put the status of non-whites to the same level as white people.
That's correct.
Yes, so then white people are
But
U.S.
in
citizens
itself,
along with non-whites.
the 14th, why would the white people need the 14th? They already had everything.
They don't.
Why would they need the 14th?
I understand that. That's the point of the 14th, was to bring them on the same level as white people as U.S. citizens.
We're not in disagreement about that. It's just
So then white people are U.S. citizens.
No, white people never needed
You just
the 14th
told me
Amendment.
you just told me you agreed with me.
The 14th Amendment the intention was to bring non-whites to the same level as the whites. That is correct. That's what you just said. I agree with that entirely. In fact,
As U.S. citizens, and if the 14th Amendment made those non-whites U.S. citizens, then logically that means that white people were already U.S. citizens, and the non-whites were brought to the same level as white people.
no, they were state citizens. It even says in the Constitution, state citizens.
Okay, then if I
And
go,
I can
agree,
prove this.
then if I agree with
this.
you, then non-whites are state citizens.
Now, hold on. So the very next day, and I can click on, I have a link here. We can go straight to the original.
I
hold on.
I really want to press you on this. If you all agree with me that the purpose of the 14th Amendment was to bring non-whites on to the same plane of equal standing in terms of rights and
Yes.
and protections as white people,
Yes.
how then do you then argue that there are still two distinct categories or classifications of non-white U.S. citizens and white state citizens?
Because the original intention, if you look at, let me go back to the treatise. If we go down to, this is way later, but we can jump around a little bit, I guess. If we go down to shit. Hold on one second. I just added this yesterday, so it may take me just a moment to find it. I found all of the original speeches when they were trying to pitch this thing. Here we go. So these are all the original quotes from the guys that were pitching the 14th Amendment, right? You can see here there was a guy named Thaddeus Stevens.
Mm-hmm.
And on June 13th, he said, your civil rights bill, talking about the Civil Rights Act of 1866, some answer that this secures the same things. That is partly true, but a law is repealable by a majority.
Right.
And all I need hardly say that the first time that the South with their Copperhead allies obtain the command of Congress, it will be repealed. The veto of the president and their votes on the bill are conclusive evidence of that. Stevens emphasized the amendment's permanence. This amendment, once adopted, cannot be annulled without 2/3 of Congress. That they will hardly get, right? And then this is to your point. This is exactly what they're saying. Whatever law punishes a white man for a crime shall punish the black man precisely in the same way and to the same degree. Whatever law protects the white man shall afford equal protection to the black man. Whatever means of redress is afforded to one shall be afforded to all. Whatever law allows the white man to testify in court shall allow the man of color to do the same. Now, different degrees of punishment are inflicted, not on account of the magnitude of the crime, but according to the color of their skin. Now, color disqualifies a man from testifying in court or being tried in the same way as white men. Now, where did this come from? It came from Dred Scott versus Sanford. So keep in mind, at this time in 1866, we hadn't had the slaughterhouse cases yet. So this is still the Dred Scott era when they're talking like this,
Well,
right?
Well, yes, this is a Dred Scott era, post-Civil War, and in the midst
Correct.
of creating the 14th Amendment.
This is in the middle of the Reconstruction time period. We're about a year and a half into the Reconstruction time
nothing that
period.
what Thaddeus says, I disagree with. I obviously
Yeah, me
agree with
neither.
everything that he says.
Me neither. And I'm
But
not.
I
I'm
don't
not,
know. I guess I don't know how this furthers your argument here.
It's not furthering my argument. I'm just showing you. Basically, you're saying these things, and I'm agreeing with you, and I'm showing you the original material as to where the agreement comes from, right? So what they were trying to do was they were trying to get the Civil Rights Act of 1866 because the South was going fucking ballistic, the black codes and everything else. They were trying to prevent the Southern states or people with Southern mentality to be able to easily get rid of the Civil Rights Act of 1866. The way in which they were trying to make it more permanent was by making it into an amendment. That amendment became the 14th Amendment.
Right.
Right. Now here's to go all the way back to your original question. Is the answer is right here. So John Bingham, February 28th, 1886 says, and this is involving the 14th Amendment, the proposition pending before the House is simply a proposition to arm the Congress of the United States by the consent of the people of the United States with the power to enforce the Bill of Rights as it stands in the Constitution today. It hath that extent no more. So what happened was the intent was good. The intent was to try to bring non-whites up to the same level as the whites.
Okay.
But because they were saying shit like this is why we have the incorporation doctrine.
No. The problem with the incorporation doctrine is that it is a result of the slaughterhouse cases effectively neutering the 14th Amendment and its applicability to the states.
But
That's the whole
U.S.
point.
citizens are not. It's a citizenship class. It's a federal citizenship class.
Again,
would fall under
U.S.
the 14th
citizen has
Amendment.
always existed since
That's correct.
The initial founding of the country.
Now
The reason
stop
why
right
they're
there,
Yes.
because
No.
people always say that the slaughterhouse cases and the 14th Amendment created one citizenship class. I can prove that's false. I can actually prove it.
No, I'm not saying it did. I'm not necessarily saying that it's that U.S. citizen and state citizen are one and the same, but the court explicitly said that U.S. citizen is created through the naturalization process. Being a state citizen, the only thing that you need to do to be a state citizen is simply to reside in the state that you're in. Like the moment I moved from New Jersey to Texas, I became a state citizen of Texas.
Yeah, but you don't have state citizenship and U.S. citizenship, as Mr. Miller goes into extensively in the slaughterhouse cases, are completely separated. You can have one without the other.
Right. Yes. If you live in an unincorporated territory, such as D.C. or in American Samoa.
No,
where they're in American Samoa, they're nationals. They don't have a citizenship rights. The same reason why in Puerto Rico is not a state, but it has U.S. citizenship by virtue of Congress.
Yeah, it's a U.S. territory.
Correct.
I'm not disagreeing with you there.
And again, that's the thing. I'm not disagreeing.
But a
with
Puerto
you
Rican wouldn't have a state citizenship class that's the equivalent to what the white people had prior to 1873 or 18. I say slaughterhouse, so I'm just going to say 1873. If you want to say 14th Amendment, 1868, fine. It's kind of the same thing. I'm going to say slaughterhouse. Prior to 1873, what Puerto Ricans have, they don't have access to what we had prior to 1873. They never have because it's a U.S. territory.
Well, Puerto Rico wasn't even a territory until like 20 years later. But that's beside the point. The point I'm making is that I understand that there is a distinction between a U.S. citizen and a state citizen. I understand that you can be a U.S. citizen and not a citizen of a state. I mean, how many Americans living abroad have retained their U.S. citizenship despite not living in a state at all? So of course that exists. I think that where our disagreement's going to be is this idea that being a U.S. citizen confers, I guess, substantially fewer rights than a state citizen. Because according to you, a U.S. citizen is required to get a driver's license, etc., whereas a state citizen doesn't have to. But
let's look at the incorporation doctrine. What does the incorporation doctrine say?
I will also we can go into incorporation. I will also point out to this idea that one of the fundamental aspects of your argument is that the 14th Amendment is inapplicable to white state citizens, correct?
That's absolutely correct.
So then,
I can prove that, by the way.
Why do we have white people who constantly file suit in federal court under the 14th Amendment, alleging a 14th Amendment violation?
Because as far as I can tell, it's just under Rule of Evidence 301. It's just a presumption.
But if it doesn't apply to white people, why are they bothering?
Because it's a presumption, and the opposing party doesn't rebut the presumption, so the presumption stands as fact in law. It's a what do you call it when both parties agree to a fact? Stipulated fact.
I mean, okay, that seems kind of weak, but I would also point out to page 72 of the Slaughterhouse Cases. I mean, maybe you saw this when you saw my live stream, where the majority opinion explicitly say, quote, "We do not say that no one else but the Negro can share in this protection. Both the language and spirit of the articles are to have their fair and just weight in any question of construction. Undoubtedly, while Negro slavery alone was in the mind of Congress, which proposed the 13th article, it forbids any other kind of slavery, now or hereafter." And it goes on to say about Mexican peonage, Chinese labor system,
Chinese coolie labor system. Yes,
yes. So this explicitly says
he's saying non-whites. He's saying all non-whites.
He's saying everybody.
No, I can
whites
prove this.
Included.
I can prove this. Hold on one second. So again, Bradwell v. State. This is it. So Slaughterhouse was April 14th, 1873. The next day, April 15th, 1873, we have a case, a glorious case, which explains all of this and proves everything in beautiful color, high definition color. So the record on this in this case is not perfect, but it may be fairly taken that the plaintiff asserted her right to a license. She's trying to get a license to practice law, and she's female, and she's white.
Okay.
Among others, that she was a citizen of the United States, and having been a citizen of Vermont at one time, she was, in the state of Illinois, entitled to any right granted to citizens of the latter state. So it's a little bit confusing. So you have an original, what I would call domicile state. You have a residency state, which is the secondary one, and then you also have her saying that she's a citizen of the United States. So you have three different classifications here, right? And he clears this up beautifully, right? This is Mr. Miller, by the way. As regards to the provision of the Constitution that citizens of each state shall be entitled to all the privileges and immunities of citizens in the several states, the plaintiff in her affidavit has stated very clearly a case to which it is inapplicable. And this is the bombshell right here. The protection designed by that clause, as has been repeatedly held, has no application to a citizen of the state whose laws are complained of. If the plaintiff was a citizen of the state of Illinois, that provision of the Constitution gave her no protection against its courts or its legislation.
I know. Again, this comes to a fundamental misunderstanding of what he was saying in the Slaughterhouse Cases. He is saying that the 14th Amendment only protected all people, of abuses by the federal government. And that, in other words, if a federal government violates my right to free speech rights through some act of Congress, then I can sue under the 14th Amendment, challenging that violation. That he said that. However, he said that the 14th Amendment does not apply to the states. So the states and the state constitutions apply, and a person who sues in federal court under the 14th Amendment that a state law violated their First Amendment rights cannot is not going to go anywhere. That thus going into the incorporation doctrine of basically the Supreme Court walking back the Slaughterhouse Cases slowly.
No.
Yes,
and again,
No, the 14th Amendment was to give the non-whites protection from state abuses, specifically the southern states.
but how can you say that when the slaughterhouse cases effectively gave a green light to Jim Crow?
No, Jim Crow was already there. The 14th Amendment was actually during that whole Jim Crow back and forth punch, one side punches, the other side punches. That was just kind of part of that whole 1856, 1866 time period.
Okay, if you're arguing that the 14th Amendment was to protect non-whites against state abuses, why did Jim Crow happen for the next 100 years after the Civil War and didn't really die off until like 1965?
Because the southern states were pissed. They didn't want any of this. They were fighting this from the beginning. There was a military occupation. The federal government did a military occupation of 10 of the southern states.
Yes, I understand that. What I'm asking is how, if the slaughterhouse cases provided non-whites with protections against state abuses, why didn't any non-white who was living in Alabama, for example, sue in federal court against these sundown laws or curfews or laws against miscegenation? Why weren't they overturned back in the 1870, 1880?
A lot of that was the slaughterhouse cases. The slaughterhouse cases was a whole shitload of cases that all got wrapped up into one giant monster case.
But those laws kept on going. Are you just saying that the states just basically told the feds to fuck off after the slaughterhouse cases?
Well, yeah, of course. So the states have always been sovereign. All the 50 states are totally sovereign. I mean, you can see that even in the in Title 48.
I mean, you also understand that the federal court system can overturn a state law, right?
It can't. They do it, but they're not supposed to. You can see that. I actually just wrote a writ of certiorari on this exact subject, and I'm actually submitting it this week to the Supreme Court. So if we go to, I'll show you the area that they use on me, that I can actually show you to prove this.
So I want to put it on the record. You are arguing that today the state of Alabama can reenact sundown laws, and the feds are not supposed to be able to overturn that by any.
The feds can't. The feds can't overturn it, but it basically becomes essentially almost like a brand new civil war, because the feds will use the 14th Amendment to say that the states don't have the right to do it within the confines of their own state. And that's why there's been so many people that have thought in the past that the slaughterhouse cases in the 14th Amendment are unconstitutional. And I'll show this to you if we just give me a second here. So I sued the SBA in state court because it was a UCC claim, which is not federal law necessarily, depending on who you ask. And
correct. The UCC is not. Has not
yeah,
been
I don't
passed
know
by
how I
Congress.
feel about that. I understand that that's a fact, but then like, how do they handle negotiable instruments in federal court? They handle it using the UCC, and then they'll go like, "Oh, the UCC is different state to state." No, it's not. Go read.
Yes, it is.
One word occasionally. No, one word occasionally may shift a little bit.
Some states have omitted whole chapters of the model UCC code.
I understand that's a vast minority. Vast minority.
So it's not the same across the states.
In fact, the UCC, not only is it pretty much almost the same throughout all the 50 states of America, it's pretty much the same in almost every country. It's literally almost the same everywhere in the whole planet. So the idea that it's not,
there may
all
be
this kind of bullshit,
some level of similarity, but it's not as if the
it's
UK
like
has
90%.
adopted the UCC.
It's like 90% at the lowest level everywhere on the whole planet.
Okay, I'm going
I can
to
assure
disagree with that, but you can say
disagree with it all you want. Now let's get
Okay.
back into 28 U.S.C. 1442. So they removed the case. The SBA removed the case from state court to federal court, and I said, you can't do that. And they said, what do you mean? And I said, well, under 28 U.S.C. 1442, subsection D6, it has the definition of a state court. The state court includes the Superior Court of the District of Columbia, a court of the United States territory or insular possession, and a tribal court.
Right.
And the DOJ attorney said, well, the word includes means it includes the other 50 states of the union. I said, where does it say that?
Well, yes.
Where does it say that?
How do you not? Are you serious?
Where does it say that?
The term state includes the District of Columbia, United States territories, and its insular possessions in Indian country. The term state court includes the Superior Court of the District of Columbia, according to the United States territory. I don't know how you can parse that unless you literally don't think that the United States, as defined there, means the 50 states.
I can prove it.
Okay.
There we go. Kaha
you can
versus
try.
U.S. So in Kaha versus U.S., he's talking about this split between federal jurisdiction and state jurisdiction. This statute is one of universal application within the territorial limits of the United States and is not limited to those portions which are within the exclusive jurisdiction of the national government, such
Right.
as the District of Columbia.
So that means
Generally
all of the 50
speaking,
states.
nope. Generally
Yes.
speaking, within any state of this union, the preservation of the peace and the protection of person and property are the functions of the state government and are in no part of the primary duty, at least of the nation. The laws of Congress in respect to those matters
Wait,
do
so
not
which statute
extend
is it
into the.
referring to?
Let me finish.
Which statute?
The laws of Congress in respect to those matters do not extend into the territorial limits of the states, but have force only in the District of Columbia and other places that are within the exclusive jurisdiction of the national government.
Which
so,
statute is this talking about?
I don't remember. Is
You don't think that
California? Well, no, not for this. I've seen enough other things. Just hold on one second. Is California within the exclusive territorial jurisdiction? We'll see
No,
if
of
they change
course
this,
not.
of the federal government.
The answer is obvious that it's of not. The state of California has its own
Okay.
state government. Nevada, the 90% of Nevada does have concurrent jurisdiction with the federal government. I don't know why you think this is a point towards you, because it's not as if the federal governments have no jurisdiction in, or federal law has no jurisdiction in the state of California. I don't know why you think that.
Well, it would only have jurisdiction under the Commerce Clause.
No.
That's the whole point of the Commerce Clause.
No.
Yes. Foreign
No.
nations, interstate commerce, and commerce with
laws
Indian
passed
tribes.
by Congress apply to everybody, not
No,
just
it
DC.
It doesn't.
Yes, of course it does.
That's exactly why Title VIII doesn't have a state citizen in it, because it doesn't have anything to do with it.
Okay.
You don't see state citizen anywhere in Title VIII.
Well, of course. Well, yes, because there's no naturalization process to specifically be a state citizen. It's
Because
only
it's a
a
foreign
U.S.
jurisdiction.
citizen. No, it's just to be a U.S. citizen, and then a U.S. citizen, depending on where they live, can also be a state citizen.
No,
Yes.
they're two totally separate things.
No,
why?
that's how
why
how
did the white
that's how the
people-
world works right now. I don't know
No.
if you understand that.
No.
But
So let's go back to the slaughterhouse
I want to
cases.
put it on the record that the only person who's making this interpretation is you. You're going against everybody, the entire body of work in legal interpretation.
No,
across
there
judges,
are a lot
across
of
courts,
people.
across
no,
other attorneys.
There are a lot of people. Ever since the slaughterhouse cases,
A
there
lot of
has
sovereigns.
been a nonstop amount of very, very well-known judicial people, and even Clarence Thomas has talked about it extensively, that the slaughterhouse cases is just not right, and it needs to get fixed. There's been a million people that have said that. It's not just me.
Yeah, I think most people say that the slaughterhouse cases was bullshit law that neutered the 14th Amendment, allowing Jim Crow to fester for the next 100 years until the incorporation doctrine came to be.
Yeah, but let me ask you a question. If your theory is correct, why would white people give Congress the ability to tell them which Bill of Rights applies and which one doesn't? Makes no sense at all.
Let me understand that. You're saying, why would white people what?
Why would white people want or allow, and how would it even be constitutional, for white people to give Congress the ability to incorporate or not incorporate the first 10 Bill of Rights at will?
Because the point of incorporation was because the 14th, as a result of the slaughterhouse cases, the 14th Amendment did not apply to alleged grievances, alleged violations of the Bill of Rights under state law. Under federal law, somebody could sue the federal government under the 14th Amendment, challenging a violation of their rights. But
That makes no sense.
It doesn't.
makes no
But
sense.
as a result of the slaughterhouse cases, it did not apply to the states until incorporation came to be.
No, that's ridiculous. We're gonna read. Let's read the slaughterhouse cases. This is
Basic
ridiculous.
constitutional law.
No, it's basic insanity. So let's read this. Let's read this.
Sure.
So the first section of the 14th article, to which our attention is more specially invited, opens with a definition of citizenship. Not only citizenship of the United States, but citizenship of the states. No such definition was previously found in the Constitution, nor had any attempt been made to define it by act of Congress. It has been the occasion of much discussion in the courts, by the executive departments, and in the public journals. It has been said by eminent judges that no man was a citizen of the United States, except as he was a citizen of one of the states composing the Union. Now, I've found tons of these.
It has been said. So
I understand. I understand.
So he's saying that that's not like law. That's not hardcore the actual answer, correct?
Well, it had been. There's tons of Supreme Court cases.
He said
talking about this.
no such definition was previously found in Congress, nor had any attempt to be made to define it by Congress. In other words, it's been an open question of
no, because look at
defines
this.
a U.S. citizen.
Those, therefore, who had been born and resided always in the District of Columbia or in the territories, though within the United States, were not citizens. The District of Columbia, U.S. territories, and insular possessions are not states. The word state shifts. When you're talking about state statutes, the word state means one of the 50 sovereign states. When you're in federal statutes, the word state means U.S. territories, insular possessions, the District of Columbia,
and U.S. states.
No, it does not.
Yes,
it never includes that. No, it doesn't.
Yes, it does.
No, it does not.
Why? Yes, it does. I don't know why.
California
you
is
guys think
not
there's so
within
much.
the exclusive territorial jurisdiction of the United States.
No, but there's concurrent jurisdiction. You know that's a thing, right?
Yes, but it's not exclusive territorial jurisdiction. I'm telling you the exact legal term.
Concurrent jurisdiction exists.
I'm saying
therefore,
it's not
the federal law
exclusive
can apply in the state of California, as well as state law of California can apply
not unless you have
within
the Commerce
territorial
Clause.
bounds of the state of California.
Not unless you have the Commerce Clause. Nope.
I know you think that, but
Nope.
I know. But Article 1, Section 8 has more than just the Commerce Clause.
The Commerce Clause was the primary door.
Yes, I know. I read Lochner before. I understand what you're saying, that the Commerce Clause has open the door to the Feds, Congress being allowed to pass a lot of legislation that
because they've
normally
made
would not
everything,
have been considered to apply.
Yes, because they've
to
made
the states.
everything commercial, and they've made everyone.
No, they didn't make everything commercial.
Yes, they did.
No,
everything is commercial.
And I always love that you guys cite that CFR provision. Is murder within that?
Yes.
No, it's not. Murder, rape, and assault are not in that cadre of
from
crimes.
the CFR 27.2, whatever the
Yes,
fuck it is. I know.
you guys
Okay,
always
fine.
cite that all the time.
There's a few things. Okay, fine. There's a few things that aren't commercial. Everything else is.
No, it's not. If you actually pay attention to what they're describing specific violations that are obviously involve a transaction.
Which is commercial.
So like prostitution involves a transaction, wire fraud, transactions,
that's commercial.
Drug trafficking, that's commercial because it's a transactional. Murder is not a transaction. Assault is not a transaction. Robbery
There's still a bond.
is not a
bond
transaction.
created associated with that, which still makes it to some
What do you
degree
mean
commercial.
a bond is created?
All right, we're not going to get into that. I don't have any.
Yeah, I know you don't want to get into that because I've heard of that one before too, and it's kind of ridiculous, especially when I worked as a law clerk, for a judge for a year, and you guys thinking that some sort of commercial transactions created with each case it's kind of funny to me because I worked in the behind the scenes and none of that actually happens. We just file your case, we put it in there and put it in archives, and we wait for your next docket hearing.
Okay.
I don't have a Wall Street number that I use your bond to play around in the stock market. But if I'm going
I'm not
to go
get
back
into all
to
that.
if I'm going to go back into, I want to go back to
No, hold on,
section
hold
here
on. We're
under
in the middle of slaughterhouse
cases. Yes, I
Okay.
want to go back to a particular portion of the slaughterhouse cases because this goes into your argument that this idea that the slaughterhouse cases created this distinct category of U.S. citizen that I guess white people aren't privy to or aren't allowed to be. And it's,
You can see that in the California Supreme Court case, Ellen R. Van Valkenburg
I know
versus Brown.
I know the Valkenburg case. Did you actually read that case?
Yes.
So you understand that involved a white female who wanted to vote, correct?
Yes.
But then you understand that the court explicitly said that she's a citizen of both the U.S. and of the state of California.
Yes, you did mention that in your stream. The reason why they said that is because she said it first. I'm dead serious.
It said undoubtedly she is.
Undoubtedly, yeah, but she said it first.
And so the court's agreeing with her.
She told them. That's correct.
So then what's the argument here?
Well, that would be under 301. I could say I'm a purple people leader, and the
You know
court
the
could be like,
federal,
all right, fine.
FedCiv Pro didn't exist until like the 40s, correct?
It doesn't. If
The federal
if she
rules didn't exist
says-
until like the 40s.
If she said that she's these things, even in U.S. versus Cruikshank, they said that a person may be both a state citizen and a U.S. citizen. May implies...
I know that may. Well,
May.
yes. Again, we already had this discussion. A Puerto Rican isn't a state citizen, but they're a U.S. citizen. Nobody's disputing that.
That's correct. I agree with you.
But I'm telling you that a U.S. citizen, a white person, can be is a U.S. citizen and a state citizen.
They may
Period, end of.
be. Now, keep in mind,
If they-
U.S. versus Cruikshank was 1876. Legal fictions were not added in under the 14th Amendment as persons until 1886. So Cruikshank was at a time period when corporations had not been included under the 14th Amendment definition of persons yet.
Okay, and
So that's very important.
how? Why?
Because in Cruikshank, they hadn't seen the confusion that was going to happen after Southern Pacific Railroad, the 1886 case where they added in legal fictions as persons under the 14th Amendment.
So I'm looking at this.
Mr. Miller is really clear about that too, as well in Slaughterhouse. But let's read a few more of these.
I'm looking at this
Let's read a few more of these.
from Miller as well.
So then all the Negro race who had recently been made free men were still not only not citizens, but were incapable of becoming so by anything short of an amendment to the Constitution.
Okay.
To remove this difficulty primarily, and to establish a clear and comprehensive definition of citizenship, which should declare what should constitute citizenship of the United States and also citizenship of a state, the first clause of the first section, obviously of the 14th Amendment, was framed.
Yeah. Also, you understand that the first section also says that the all persons born and naturalized in the United States are citizens of the United States and of the state they reside.
Yes, but the word reside is obviously where I'm going to have a problem with that. But yes,
Of course you are. So, so then, therefore, a freed African slave can be a U.S. citizen and a state citizen.
Well, they reside in the state. I think it's never really been. It's never really even been talked about. I think functionally it doesn't work the same because they're resident.
Yeah, they live there. If they live there
No.
for a certain period, yes.
No,
Yes.
I can prove that one too. If we
I'm
go
sure you
to-
can, but you haven't really proven anything so far.
Well, you say that, but we'll see what the audience thinks.
Of
So
course.
if we go to Barn, let me see if I can find this real quick. Because I love these non-SovCit guys, and they come and they talk to me about the word domicile versus the word resident. And I found this. This is pretty interesting. Look at this.
Uh-huh.
This is 36 USC 70501. The foundation of the Federal Bar Association is a federally chartered corporation. The corporation is declared to be incorporated and domiciled in the
Okay.
District of Columbia.
And?
Domicile and residence, there's a rich history of
I understand
definitional
there's a
difference.
distinction. I understand there's a distinction between domicile and residence. What does this
Okay.
have to do with the 14th Amendment saying that
because they
all persons born
reside in a
naturalized,
state.
so then
They
there can be
reside
U.S.
in
citizens.
a state.
So they can be U.S. citizens, or excuse me, they can be
Yes.
state citizens.
Well, it's a whole that they reside in the state, so it's still it's a lower class of state citizen. It's not the same class.
Oh, so now there's a secondary class of U.S. citizen. First you say that there's federal U.S. citizen and state citizen. Now you're saying that there is a subclass of state citizen.
Well, I don't. That has never been. No one's ever brought that up in any case. There's no way for me to even talk about that. There's no precedent.
Well,
there's
yeah,
no
this is
case
something
law.
that you kind of made up on your own.
No, the word
Yes.
reside is the word reside. It's not the word domicile. Period. End of story.
I'm not saying
People
that
like
they're
to make it.
I'm not saying
people,
that I'm not saying that they're completely similar in every aspect. I'm not saying that at all. I'm saying that the language of the 14th Amendment is clear.
It's not clear.
A freed African slave. African slave could be a citizen of California and the United States. Yes.
A freed African, yeah, but it includes all non-whites. It's not just. It was originally created for.
And also, white people are also
No.
U.S. citizens.
Why would white people need this? Why would white people need it? We never needed it.
It's not a question of whether or not they need it. It's the fact that they were already U.S. citizens. Freed African slaves are also now U.S. citizens and state citizens.
No.
Yes.
Let's get into some more. No, let's get into some more quotes. He talks about this in Slaughterhouse.
I'm looking at page 73 of the Slaughterhouse cases, and you even have it right there. You're highlighting it right there. I don't know how you think that you could read this and think that it actually supports your argument. The main purpose to establish the citizenship of the Negro could be admitted of no doubt. The phrase subject to jurisdiction, blah, 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 blah. But it says it overturns Dred Scott by making all persons emphasis added by emphasis in the original, I should say, born in the United States and subject to jurisdiction, citizens of the U.S. It's saying all persons. It's clear the intent of the author is saying that all persons is meant to mean everybody, not just non-whites. Everybody.
I can show you. Check this out. 42.
Oh
we'll go to the Civil Rights Act. Let's go to the Civil Rights Act. Look at this. Equal rights under the law. We see it now in 42 U.S.C. 1981. All persons within the jurisdiction of the United States shall have the same right, and it's the same we saw before, as is enjoyed by white citizens.
Yes, white U.S. citizens.
Well, that meant something. That just meant a citizen of a state prior to this point. That's what Mr. Noy was saying when he's saying, there's been all these people saying forever that there was no such thing as a U.S. citizen, but only a citizen of one of the states, right?
I mean,
and then we also
Will goes on to say he as an individual, he must reside within a state to make him a citizen of it. But it is only necessary that he be born and naturalized in the United States to be a citizen of the Union. How is that not referring to white people?
Well, that would be, so that's simple. If you want to naturalize as a U.S. citizen into a state as a state citizen, you would do it under the Naturalization Act of 1802.
What about born?
Born
so
in
if
a
a white
state
this sentence explicitly says if a white person gives birth to another white person, that white baby is a U.S. citizen.
Where?
I just read it. It is only necessary that he be born or naturalized in the U.S. to be a citizen of the Union.
That's this one here? This one that I highlighted here? To be a citizen...
No, this is in Slaughterhouse.
A citizen of the... Okay, right here. He must reside... The next observation is more important in view of the arguments of counsel in the present case. It is a distinction between citizenship of the United States and citizenship of a state is clearly recognized and established. Not only may a man be a citizen of the United States without being a citizen of a state.
Again, I'm not disputing that you could be a U.S. citizen and not a state citizen.
But an important element is necessary to convert the former. So to convert the former, meaning U.S. citizen. No, former, the first thing you mentioned was the citizen of the United States.
Converting
into
the former
latter
U.S. citizen into a state citizen.
Yes.
Okay.
He must reside, which would be the Naturalization Act of 1802, within the state to make him a citizen of it, as per exactly 5 years, was what it says in 1802 Naturalization Act. But it is only necessary that he should be born or naturalized in the United States to be a citizen of the Union. Okay.
Yes. Okay.
That's you. It is quite clear then that there is a citizenship of the United States and a citizenship of a state which are distinct from each other and which depend upon different characteristics or circumstances in the individual.
Obviously.
Now, this is the part where I think he does the best job of clarifying between the two right here, right?
Uh-huh.
Of the privileges and immunities of the citizen of the United States and of the privileges and immunities of the citizen of the state and what they respectively are, we will presently consider, but we wish to state here that it is only the former which are placed by this clause under the protection
of the federal
Constitution.
Yes, he's saying
and that
the,
the latter, whatever they may be, are not intended
to have any protection by the paragraph of the amendment. Yes, Again,
if then
he's saying
there is a difference between the privileges and immunities belonging to a citizen of the United States as such and those belonging to a citizen of the state as such, the latter must rest for their security and protection where they have heretofore rested, for they are not embraced by this paragraph of the amendment.
Okay, I'll ask you, what do you think he's saying with those two paragraphs?
He's saying white people already had all this shit. None of this shit has anything to do with you guys. It's us trying to raise and protect the non-whites from all of the horse shit going on mainly in the southern states that are just horrible, and it shouldn't happen in our country.
Okay. What he's saying is that the Privileges and Immunities Clause of the 14th Amendment is there only to protect violations made by the federal government, Congress, and that it is not intended to protect. It is not intended to protect the privileges and immunities of the citizens of the state, aka state law.
Why would they say that on the heels of 10 southern states doing horrible, awful things to release
because
freedom?
Miller was an asshole.
No, Miller was
he was an asshole. He neutered the 14th Amendment. Again, that's why incorporation was needed to bring the protections of the Bill of Rights to people who are being violated by state laws.
You don't know anything about Mr. Miller. He spent 21 years. He was working as a doctor. He taught himself law. He released his slaves.
I don't care.
He moved from a state that was very slavery oriented. He moved to another state that was more friendly. I think it was Iowa. When he moved, his slaves helped him move. And then as soon as he finished moving, he released the slaves. He started teaching himself law. He got into the judiciary. He was in the Supreme Court for 11 years. His middle fucking name, for Christ's sake, is Freeman.
Okay, I don't care.
He was trying to release the slaves for like 21 years of his life, and you say he's an asshole? It doesn't make any sense.
Yes, he is an absolute asshole. I think
he's not an asshole at all.
Yes, he is. The only I think other scholars have said that the reason why he put this, he made this decision was in respect to Louisiana, because at the time this decision was handed down, Reconstruction was still in effect. There were still Union troops in the southern states, and
10 of them,
yes, and so there was almost equal distribution of whites and blacks in the state legislature in Louisiana, and he felt that if he argued that
the military was trying to push out the Confederates,
if he argued that the Privileges and Immunities Clause did apply to the states, then he could affect the majority in the state house, in the state legislature in Louisiana. But either way, I don't know how
it's
you think
crazy and makes no sense, because
I don't know
black
how
people were trying to get federal help because they were in trouble in the states. Not
yes,
the
and
federal
and
government
by
was not
virtue
attacking
of
the
the slaughterhouse
blacks.
cases, they got fucked.
They didn't get fucked. They got the exact protections they wanted.
What was Jim Crow?
Well, Jim, it was 100 years of them trying to get this stuff applied, and it was very difficult because of the separation of powers between the states and the federal government.
But Jim Crow lasted this long because of, in
understand.
part, the slaughterhouse cases.
The slaughterhouse cases, it doesn't make any sense. Why, if your theory is correct, why would the blacks need protections from the federal government? The federal government wasn't doing anything to the blacks. It was the states.
Right, and then the Union troops were there to protect
Just common
them.
sense makes
And
no
then
sense.
after
That makes
the
no
and
sense.
then by virtue of the slaughterhouse cases, it effectively meant that a black person could not sue in federal court against a state law that he felt was violating his federally protected constitutional rights.
No, that's the whole 42 USC 1983. That's the whole purpose of 42 USC 1983 and 85. That's the whole fucking purpose, was to give the blacks federal protection from state atrocities. That was the entire point. Look,
And
42
it
USC
didn't stop any of the
1983.
states. It did not stop the states from
I
segregation
understand.
or Jim
It's-
Crow.
Okay, you're talking about effectiveness. I'm not even talking about effectiveness.
Okay,
I'm talking about
let
just the fact.
me ask you. Okay,
Just a fact. Now, hold on.
I know you wanted to go.
42 USC 1983 civil action for deprivation of rights. Every person who, under color of any statute, ordinance, regulation, custom, or usage of any state or territory or the District of Columbia, subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution. Now, the caveat here would be any incorporated immunities secured by the Constitution and laws shall be liable to the party injured in an action at law, suit in equity, or other proper proceeding for redress, except that in any action brought against a judicial officer for an act, blah, 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 blah.
Why do you think they put in?
Now check this out. So if you have this, now let's look at 4 USC 71. Where is the permanent seat of government? We all know that. All the part of the territory of the United States included within the present limits of the District of Columbia shall be the permanent seat of government of the United States. Okay, fine.
Okay.
Now let's look at 4 USC 72. All offices attached to the seat of government shall be exercised in the District of Columbia and not elsewhere, except as otherwise expressly provided by law. So the whole point...
What do you think that means?
It means that anything that's within the exclusive territorial jurisdiction of the United States, which would be certain offices or certain parks or certain ports...
That's incorrect.
That may be attached to the seat of government shall be exercised in the District of Columbia and not elsewhere, except as all federal courts essentially fall under 4 USC 72.
That's incorrect.
That is not incorrect. That's why it's the
is
whole
incorrect.
point of federal.
No, the
federal means the District of Columbia. How can federal
that-
not mean 4 USC 71? That's what federal means.
Do you not know what federalism even is?
Yes.
So
But-
you
but
understand
the
that there are
seat
laws.
of
You
federal-
understand that the law. Are you literally telling me that the laws of Congress, from healthcare to immigration to their criminal statutes, all of that only applies to like the 3 square mile of DC and Puerto Rico and Guam and whatever?
Exclusive territorial jurisdiction of the United States.
No. You're
Exclusive territorial jurisdiction of the United States.
Again, you completely ignore the concept of concurrent jurisdiction, but I mean, I don't know how I can explain that to
Concurrent
you.
jurisdiction would have to be established above and beyond the idea that it's not within the exclusive territorial jurisdiction.
Right, because and federal laws apply to all the different several states.
No, federal laws
based on
apply
what
if
Congress,
you can gain you can gain federal jurisdiction, which would be federal question, diversity, etc.
Yes,
you know, 42 USC 1983
again, that's the
does
point
not
of
have
concurrent jurisdiction.
Hold on. 42 USC 1983 claims do not have by themselves a federal jurisdiction. But did you know that 42 USC 1985, which is the conspiracy version of 83, does have its own entirely separate federal jurisdiction code? Did you know that? So an 85 claim would be under the exclusive territorial jurisdiction of the United States, whereas an 83 claim would not. They would need to establish diversity or federal question.
Wait, so why is 1980 if all federal laws are only applicable to DC and Guam and Puerto Rico, what?
All the
How
U.S.
would- how
territories
would-
and insular possessions.
Yeah, why would Section 1983 apply to the states?
It's a federal protection for non-whites being fucked with and attacked in the states.
But the state, but again, you told me that this, if it doesn't have exclusive jurisdiction, federal law doesn't apply.
Well, it would be a federal question.
No,
It
you
would be
told
under the
again.
idea of a
No.
federal
I'm
question.
sorry. You're walking back now. You told me that the federal law does not apply when it doesn't have exclusive territorial jurisdiction over a territory, aka Puerto Rico or DC or Guam. But now you're saying that 1983 can apply to the states, even though it's a federal statute.
The idea of the cause of action being a federal question would apply under, what is it, 28 USC 1331, I think is federal question. Or is it diversity?
Yes.
I forget. Now, from there, you would have to go into establish further jurisdiction over the parties. So at that point, would both parties be under the exclusive territorial jurisdiction of the federal government? So there's like two layers to it. So you would have a federal question, but then you'd have to now move into, do you have exclusive territorial jurisdiction over the parties? For example, a state citizen that's not a U.S. citizen, they wouldn't be able to establish that necessarily. That would be under diversity. You would have to go under diversity for that.
Again,
Diversity specifically says 28 USC 1331. No, is it 1332? Yeah. Diversity specifically says in subsection A1, citizens of different states.
Yeah. And
it has to be at least 75,000 as well.
Okay. I don't know how this furthers your argument here.
I don't know either.
Again, you're telling me you keep telling me that federal law does not apply to the states because
Well, it
there's
needs to be
exclusive-
established above and beyond the exclusive territorial jurisdiction of the United. So exclusive territorial jurisdiction means like practically ownership. U.S. territories and insular possessions are practically just owned properties of Congress.
Okay.
The states are not owned property of Congress. They wouldn't fall
because
under
federalism
the exclusive
exists,
territorial jurisdiction
and the states
of
are
the United
considered sovereign, and the states are considered sovereign entities. So
That's correct.
The
so what would it fall
applicability
under? The
of-
Commerce Clause.
So the feds can only apply laws passed passed by Congress to the states if they are within the specific confines of Article 1, Section 8.
I don't remember what that is, but yeah, sure, fine.
Article 1, Section 8 lists the various subjects of what Congress is allowed to regulate.
Oh, yes.
So
I remember this.
Congress can establish taxes that are applicable to the states and state citizens. It can apply various regulations, post offices. All of these things are the specific subjects that the Congress can pass, and they apply to everybody, state or non-state.
No, I can prove that's not true. Let me just pull up the legal tender cases, because they cover this a lot in legal tender cases. If we go to, because this is exactly how they created Federal Reserve notes, actually, what you're talking about right now, right? So if we go into...
Well, the Congress has the exclusive right of coinage. Yeah. Because
but the way they describe it, in legal tender cases is absolutely fascinating, because they actually do a really great job of delineating the two differences. Let me see if I can just rapidly find this. Actually, you know what? It's in one of my cases. I can pull this up. Let me just pull this up here. This is from a reply brief that I filed in to an appeal. Let me see if I've got it here.
Is this the one where they identified your arguments as being sovereign citizen?
I mean, that's pretty much all of them.
Yeah.
Let's see here. Not that I give a shit, because I go off the Roger B. Taney definition. And I love being called a sovereign citizen. It makes my dick hard.
So okay, so
Let me see the reply brief.
you're conceding that the courts are identifying your arguments as tried, tested, and found wanting, and are full of shit.
No. I've changed a lot of it over and over again. It's starting to get better. I just got to figure out my main issue is procedure, but I'm getting a lot better at it.
Yeah, but in any one of your cases where the court has actually made a decision on the merits, they've all said that this is bullshit. And it's
I've never
it's been proven as bullshit.
I have never ever had any of my cases decided on the merits ever. It's all procedural.
The motion to dismiss.
Yeah, well, it's procedural because we never even had a hearing or anything. I never had a chance to really talk at all, and they said nothing.
In that one case, did you guys not have an actual oral hearing?
I have literally never, never, ever had an oral hearing in any of my cases. Ever.
So then which case did I look at where there was an actual transcript of an oral hearing? Was that one that you didn't participate?
Yes. That's not mine, me personally, no.
Okay.
That's another case. So I found it. Here's the case. It's they're talking about vapor money theory, right? So
yeah, that's where they say that they.
It's a joke. It's just pure ignorance. It's literally I'm a retard. Vapor money theory. I'm a retard. So look,
they think that you could get money for nothing.
They don't even know what money is. Anyways, Juilliard v. Greenman.
Money, Federal Reserve notes, fiat currency, whatever you
we're
want
not
to call
get
it.
into all that. We're not
whatever
getting into
you
all
want,
that.
whatever you use to pay your rent or electric bill.
We're not getting into that. We're not getting into. I'm not going down that rabbit hole.
I know you
way
don't.
too much.
I know you don't want to.
Use it as fine. I don't want to add another hour to this and start talking about that bullshit. We're not talking about that bullshit right now. You don't know what money is. Nobody knows what money is. It's fine. I get it. I'm like over it. So Juilliard v. Greenman, and we're going to learn what money is here in just a minute, a little bit at least. So by the Constitution of the United States, the several states are prohibited from coining money, emitting bills of credit, or making anything but gold and silver coin a tender in payment of debts. But no intention can be inferred from this to deny to Congress either of these powers.
Okay.
It appears to us to follow as a logical and necessary consequence that Congress has the power to issue the obligations of the United States in such form and to impress upon them such qualities as currency for the purchase of merchandise and the payment of debts as accord with the usage of sovereign governments. The power, as incident to the power of borrowing money and issuing bills or notes of the government for money borrowed, of impressing upon those bills or notes the quality of being a legal tender for the payment of private debts, was a power universally understood to belong to sovereignty in Europe and America at the time of the framing and adoption of the Constitution of the United States.
What are they saying there?
They're saying that the states can't create and have a negotiable instrument. So a Federal Reserve note is a negotiable instrument. It's not gold and silver coins. It's not even a promise to have gold and silver coins.
A state cannot issue its own currency.
The word currency includes negotiable instruments. The word money does not include negotiable instruments. Two totally separate terms.
But a Federal Reserve note is considered money.
No, a Federal Reserve note, and I can prove that very, very easily, is absolutely not.
Okay, so then
if you go to
Congress,
let me show you. Let me prove it. Let me prove that. Hold on. Let me prove it.
I'm
Stop.
paying Comcast
Let me prove it.
in
Let me prove it.
instruments.
UCC 3-102. This article applies to negotiable instruments. It does not apply to money. And they covered that a lot more in UCC 3. Money.
I don't know why.
It's totally different.
Yeah, I know you have a hard on for UCC 3. I don't know. I don't understand why. But
fine, then you don't have to understand why. That's okay. I don't mind if you don't understand.
Okay, but neither does the court, and the court doesn't care about your arguments about UCC 3. They're going.
Well, that's not true. That's not true. We haven't really established anything that really even covers it yet. So no, that's not true. I mean, I'm 39 years old, bro. I ain't going anywhere. Like, you think I'm not going to be banging on this door for 10 fucking years? Like, they're going to open it eventually.
Sure.
I mean, we'll see. Maybe they won't. I mean, that's fine.
I'm gonna take your
I'm
word
having a
on
blast. Yeah, fine. So, anyways, here's another section. We have oh no, that's not it. This one here, right? So there was no coin. They call it specie. This is like the technical term you'll see a lot in a lot of the cases during the legal tender cases. Specie. That's referring to gold and silver coins, which is money, and it's totally different than what you have in your wallet, which isn't money, by the way. In general circulation in the United States between 1862 and 1879, both gold and silver were treated in business as commodities. This is the same thing we have in today's world. So ever since 1933, gold and silver coins are treated as commodities, and they removed them. Now, negotiable instruments have been considered the same as cash for ages in our country. I mean, I have all the way back to Swift.
Right. And then,
the Swift
and then
case,
I
Swift versus
understand what
Tyson.
you're saying. And then I think in one of your first case, you argued that a purchasing agreement was a negotiable instrument.
Well,
for a house.
the very, very first case that I have listed on Williams and Williams is pretty rough. I literally had no previous training. I just dove out of the plane basically without a parachute. So I'm not going to sit here and talk about my first few cases. I'm not going to. They're really not very good, frankly. So I learned just literally from like sheer like battlefield experience. So I'm not going to sit here and say that my first mini cases were really any good, frankly. I'm not going to say that. But I'll tell you right now, I've been doing this for a little over a year and a half, and there ain't no motherfucker on the planet that's learned this much shit this fast.
I mean, when you
so I need more time. Like I need more time.
I mean, when you find tried and true sovereign citizen arguments that have been in place since the '60s, of course you're going to learn a lot. I mean, if you go down the rabbit hole deep enough.
Well, no, I'm trying to get all this stuff going. I've been trying for a year and a half, and I need more time, but I'm doing it. I'm getting there.
Getting where specifically?
To the point where we start getting into making it past a motion to dismiss, or getting into discovery and getting into the merits of the case. I've never really gotten into the merits of any of my cases. So
with the goal being that you can get out of your mortgage payments by having the Treasury Department pay for it.
No, that's not at all what I do.
Then
certain things are negotiable instruments under UCC 3-104, and certain things are not. It just depends on, you have to analyze each document individually to see if the document falls under 3-104 or it doesn't. That's the definition of a negotiable instrument. So I don't.
So then
you can't just say generalized things and then expect me to. If you have a promissory note, which is defined as an unconditional promise to pay as per UCC 3-104, then yes, it is a negotiable instrument.
A purchasing agreement, right?
A purchasing agreement, if it's an unconditional, well, it depends. If there's a condition to payment, which would fall under 3-106, a condition to payment, a purchase agreement would be like, it depends on how it's worded. So if you have a purchase agreement that says, on this date we'll deliver, and then once we deliver, you have to pay us, that would be a condition to payment in accordance with 3-106. That would not be a negotiable instrument. That would not be a promissory note legally under 3-104.
And as somebody who went through the process recently on selling a house, I can tell you that vast majority of purchasing agreements for real estate almost always have conditions to them. So I don't know why you would ever think that that was a negotiable instrument at all in your first
keep
case.
in mind, Artie, you went to law school, you did all this stuff. I literally just jumped out of a fucking plane. I filed a federal case and just didn't even have a fucking.
Do you not think that that's kind of like a risky thing to do for another person who's dealing with real estate that can possibly cause millions of dollars, as what was alleged in the agreements?
You'll need to reread the question. I don't understand the question.
Do you not think that that is a huge risk to jump headfirst into something that you admit that you're not really knowing much about what you're doing in a very contentious purchasing agreement with homeowners who are dealing with property that are worth millions of dollars, and the
I think it's
of
risky?
failing to close on a house can cost them a lot of money, right?
I'm not entirely sure exactly how to answer your question. I love Risk. I love motorcycles. I love women.
Well, it's not just your risk; it's the risk of your, clients. For lack of a better word.
What kind of person do you think would hire someone like me to do this kind of shit?
An idiot.
Fine. Somebody who likes Risk. That's for damn sure.
Okay. I mean, you know,
if Risk makes your fucking dick hard, I'm your guy. I don't deny it. I'm not saying that ain't true. I'm not denying. I'll tell you straight up. If you like Risk and it turns you on, I'm your dude.
And I guess they paid for it, right?
Oh yeah.
Yeah. And you hold yourself without any responsibility for what happened to that deal that fell through.
So what we do when you say so what deal that fell through? What do you mean by responsibility? What do you mean exactly?
So my understanding from your very first case, it involved.
I hate that we're bringing up the first case, just by the way, because it's just a really shitty case.
Purchase or sale of real property, and the folks there, in the middle of the purchase or sale, they went to you, where you argued that the purchasing agreement, which in my terms, when I was doing it, I was under contract for the sale of a home. I assume that's what you're meaning of a purchasing agreement. Said that contract,
I'll answer
that
your question.
agreement in and of itself could be exchanged for cash.
Well, first and foremost, a negotiable instrument by itself is cash. So when you say exchange for cash, it's not really a negotiable instrument. Is cash.
But
you're saying that one type of cash to another type of cash.
Was a negotiable instrument.
Hold on. I thought that those instruments at that time were.
How?
Because I thought they were unconditional promises to pay. Or
have you never bought or sold a house before?
No, of course not.
So that's what I'm talking about here. If you were an actual attorney, you would be put up for malpractice.
I mean, I don't know how many attorneys you've dealt with, but the amount of malpractice, you say that, but no, they wouldn't probably, honestly.
If I were to advise my client that a purchasing agreement, while the sale of the house hasn't closed yet, could be exchanged for cash, and and try to force the title company to do that, yes, I would be put up for legal malpractice, and I probably would have my license suspended. Okay,
I don't know what to tell you. I mean, like I said, it was. I never went to school. I just went straight into.
I know. You never went to school. You dove headfirst, as you mentioned.
Yeah.
You're going in blind. So
I don't. See, you're from your perspective. You're saying after having done this for many years, after having gone to school, after having done this, it doesn't make any sense why you would X. I'm not telling you it did make sense. I'm not telling you it should make sense. I'm telling you I was a guy who jumped out of a fucking plane, and that was it.
And so I guess all the responsibility and the consequences are on the people who took your advice.
I mean, a lot of that stuff is still ongoing even to this day. I mean, there's so many other things that have happened since then in other cases, and we're still in the middle of all sorts of different things with it. A lot of it's posted on the other cases. So when you say responsibility, I don't know exactly what you're referring to. A lot of all of that stuff and all of those cases involving that particular person is all still in progress. So I'm not too sure. So if your definition of responsibility was, are you sticking with it and ensuring that you take this thing to a final product or that you achieve closure, the answer to the question is yes, I'm still doing it to this day, and we haven't completed that process.
Well, I think is the case not effectively moot? Didn't the sale of the house fall through?
Yes, the sale of the house did fall through. Yes, it was already pretty much fall through when I arrived. It had already kind of fallen through by the time I had arrived on the scene.
Okay, so then.
You use the word responsibility, it's just really hard because everybody seems to have a different definition of that. If you use a different term or idea, I could probably do a better job of answering the question.
Well, I would say
if you were more specific and you were like...
A licensed attorney has a duty to act in their client's best interest and to provide them with the advice that would serve your client's best interest. And I would say that a base level of understanding of negotiable interest and contracts for real estate, it's obvious that a purchasing agreement is not a negotiable instrument that you can take it to a bank and get cash for it based
Yeah,
on what the purchase is for.
I'm not denying the fact that that was a disaster. I mean, it literally was a disaster. I mean, it's not anything that we haven't handled since. It's all wrapped up into a nice little bow now today. But at the time,
you could say that your subsequent cases have not really been successful.
it depends on how you define successful. If you define successful as winning through
On the merits.
No, I've never really gotten into the merits on almost anything. No.
Well, I would say the motion to
the
dismiss
reason
was
behind that,
close enough.
the reason behind that mainly is procedural. I have had a lot of procedural. So the timeline is really weird and goofy. So the first year, I wasn't even reading case law. I was just pure horseback raw dog in the whole thing. And then by December, I was so defeated and so beaten down that I said, all right, I'm going to finally start learning procedure and I'm going to finally start reading cases, which I know sounds absolutely insane to you, but that's just the truth of what happened. In December is when I started reading a lot of cases, and I was reading cases like crazy. I kind of fell in love with it. I fell in love with the story and the history, and then I started researching a lot of the background of the various Supreme Court guys, like, for example, obviously Taney, John Marshall, Mr. Miller. I started getting in a lot of their histories. I just found the whole thing fascinating, right, in the history of the United States. And then started getting into procedure more recently, probably in March, April. It's kind of when I started getting into that. Procedural, I was very naive and very headstrong in thinking that I could somehow get into the merits of the case without really knowing anything about procedure, which is, I know to you, that's going to sound like the most batshit thing you've ever heard in your life.
Yeah.
That's just, I don't know what, it's just a fact. I don't know. You can make fun of me for it. Fine. I don't even disagree.
I would say that I would be hard pressed for you to put yourself out as a law firm or a law group if you don't have the base level knowledge of federal rules of procedure.
Well, now I understand that. But you also have to keep in mind, too.
But you took on clients when you didn't understand that.
Well, the idea of taking on clients in your world is very different than in my world. I have a power of attorney, an international power of attorney, and
which doesn't make you a lawyer, right?
Well, it's attorney in fact would be the legal term.
Right.
And I put that everywhere. I don't put attorney at law anywhere. I don't put attorney at law anywhere. How's the word attorney? You tell me.
But you're practicing law. Effectively.
No. The definition of practice law means making an appearance on behalf of a plaintiff or a defendant.
You are helping clients draft
I have never, ever made an appearance on behalf of a plaintiff or defendant except my sole proprietorship.
Except when you try to interject yourself in a hearing in that first case and the plaintiffs try to file a motion to compel the defendant's attorneys to talk to you or to respond to you. So
but that wasn't.
You have filed memos on their
that's
behalf.
Not an appearance. That's not an appearance. I did not make an appearance.
You filed memos on their behalf.
I did not file that. I have never, ever filed anything on behalf of a plaintiff or defendant. That's not me, except my sole proprietorship. I assure you, I will sign an affidavit under penalty of perjury.
Why were you trying to get yourself to be taken seriously by defense counsel? In that case,
the client filed a motion to compel communication with.
But my understanding is that the defense counsel said that they wouldn't talk to you, but they would allow you to listen in on a conversation between the plaintiffs and yourself. So you did appear. They just didn't want to talk to you.
No. In a private conversation
has nothing to do with. I'm sorry. I don't think you understand that you don't have to actually physically enter a courtroom to be acting on behalf of a client.
No. The definition of the word appearance means filing something on behalf of or speaking on behalf of in a hearing or any sort of on behalf of.
What you tried to do, and defense counsel said no. You're not an attorney. We're not obligated to talk to you.
But the idea that the client filed a motion to compel communication, and the idea that that motion to compel communication was denied, none of that or anything that happened before it or anything that happened after it would be legally classified as me making an appearance into anything. I never made an appearance.
Even though the judge in that case explicitly said that you were practicing law.
Yeah, but here I am, and it's just horse shit. I wasn't, because the thing, practice law, I would have had to make an appearance. I never made an appearance.
But you were giving them legal advice, were you not?
That's not making an appearance. That wouldn't be practicing law as per the definition.
Giving legal advice is in part practicing law.
That's under the whole U.S. citizen. You have to be a resident of a state. That's under the business and
yeah, I
professions
know
code.
that goes into your whole thing that you get out of jail free card is your whole thing. Oh, I'm not a resident of the United States, even though I'm literally living in California. But yeah, that's not how the world works.
The word domicile I just showed you. It's used even by the Federal Bar Association in terms of their relationship with the District of Columbia.
So are you domicile or are you a resident of California?
I'm domiciled. I've never been a resident of California, ever.
What does your birth certificate say?
I don't have a birth certificate.
You don't?
No.
Oh, you don't have a social security number?
Nope.
Oh, I bet you do. I think you do. But we don't have to.
Fine, then you prove it. You see how that works? You prove it. Fifth Amendment.
If you were born within the territorial confines of the United States,
you prove it.
You likely have a birth certificate. And a
you
social
go out
security
and
number.
find all the evidence and submit it, and then I'll
Okay,
file
so
it in opposition. We'll play that game.
Well, I mean, are you worried about ICE coming to your door?
No, not at all. Not even.
Why not?
I'm the whitest guy in the world. I'm like a ghost.
You know there were white Hispanics, right?
Yeah, but dude, I'm a literally fucking albino, bro.
You never met my dad, and I'm Puerto Rican. So,
the color, the lighting in the room is a little bit yellow. I can tell you have a little bit of a tint to your skin. Look at me, bro. Look at me, bro. I'm trans fucking lucent.
Okay. So you're not worried about ICE because you passed the paper.
Well, keep in mind, I am filing a writ of certiorari. Like, I am very excited. I have put a lot of time and effort into this. I went and printed all the booklets. These are the booklets as per the Supreme Court rules. And you can't see it. I have a couple boxes right here. I don't know if you can see it. Those are all of these booklets. And I've got the word count. I got to print that up. I got to go get the cashier's check tomorrow. I've already got the Solicitor General of the United States. He's already being served in 2 different ways because the process server couldn't get into the building. So I sent everything certified mail, and then I also gave her a different address. So
I mean,
this bad boy is getting filed real soon, like probably in the next 6 or 7 days. This thing is going to be in the mail. So keep in mind.
That's really cool and all, but I think you understand what the odds are of whether or not this court is going to take up the case.
Dude, maybe 1/5 of 1%. I understand that. But I tell my audience that. I'm very clear about that. I'm not delusional. I totally get it.
Okay, so.
But the thing is, I'm doing it.
Yes, you are filing actions, and anybody can file an action in federal court. I mean,
well, dude, have you ever filed a writ of certiorari, bro? This shit's fucking insanely complex. They have special dimensions for the paper. It has to be a minimum of 60 pounds on the inside. It has to be a minimum of 65 pounds for the cover. It has to have a minimum of 2 staples.
Yes.
I have to put tape over all the staples. I mean, fuck, dude. I mean,
yes, formatting rules are a pain in the ass. I understand that very much so.
In the Ninth Circuit, when I was in the appeal, that was super easy. They gave me a pro se template, and it was like Sesame Street retard shit, and I just filled it out, and it was great, right? And I get into the Supreme Court, and it's like,
actually,
oh my
that's a
God.
good question. Why are you? That's actually a good question that I just saw in chat. Don't you need to actually be specifically admitted to file actions in the SCOTUS?
No.
Are you sure about that?
Yeah, it's all through the through the rules. It's all through the Supreme Court rules.
I'm pretty sure you need to be specifically admitted by the Supreme Court in order to file actions on behalf of a client.
Oh, on behalf of a client, yes.
And pro.
I'm pro se.
I don't know if they allow pro se, but I have to double check that. But
yeah, they call it they call it an unrepresented party. The terminology is a little bit different, and they also use the term pro se as well. Okay. You can check the rules. I'm doing it. Sure. You can check the rules. $300 fee, filing fee. Yeah, I mean, yeah, you can pro se your ass all the way to the top, my brother.
Sure. Man, I don't know where we left off, but it's we're about close to 2 hours here. So I don't think
I mean,
don't
anything
know
else
if we,
you wanted to bring with you, or anything else you wanted to ask, or anything? I
mean-
mean, you can look at my writ of certiorari, but a lot of it is just the treatise on the word person minus all the colorful language, essentially. If you want to,
right.
I mean, to some degree.
I think ultimately, I mean, we were kind of at an impasse. I think we obviously have fundamental disagreements on the interpretation of the slaughterhouse cases, what the effect of the slaughterhouse cases was, in terms of constitutional law and applicability to.
I don't think anyone agrees about what the slaughterhouse cases says. Hardly at all.
I think there is a general consensus on what the slaughterhouse on the
Barely.
results of the slaughterhouse cases are.
Barely.
I think
it's
obvious,
the one case that has the most amount of contention.
I think the most obvious one is the one that you disagree with the most, which is that it effectively neutered the ability to apply the Bill of Rights to state laws until incorporation, over the years, walk back that decision. But again, I think that's a fundamental disagreement that we have in terms of the results of the slaughterhouse cases. I think we have a disagreement on, the nature of person, of individual.
Why would white people who are
of,
already citizens tell Congress to take away their Bill of Rights and then incorporate them later? It doesn't make any sense. Take away my Bill of Rights, please. Why would we go to Congress and say, Congress, please take away our Bill of Rights and then incorporate them later? I mean, the Second Amendment wasn't incorporated until 2010.
Right.
Yeah, white people did. The way they pitched it, a lot of these guys like Thaddeus and fucking John and all these fucking guys were all white guys. So
right,
it was a lot of white guys doing this.
Again, that goes into our fundamental disagreement, where I am arguing that the intent of the 14th Amendment was to bring non-whites to the same level as whites as U.S. citizens, but you have a disagreement there.
No. We've already covered that. That's also what Thaddeus said and John and all those guys. That's exactly correct. But the thing is that it was so there was one elevator. There was one class, and that's in Dred Scott. He covers that really pretty good, right? And keep in mind, I don't think you like Tandy very much. He was already the Chief Justice for 21 years by the time Dred Scott came out. And if you actually read the case, you'll see the amount of research and historical information in that case is unbelievable. They go all the way back to the English Empire. And it's very, very detailed. And you know that Taney got rid of his slaves in 1818, and he actually hated slavery.
Well, when it comes to Dred Scott, I'm going to say it here, and maybe I don't know. I don't think it's going to be controversial to my audience, because I think my audience understands me. I understand that at the time of Dred Scott, I'm not necessarily disputing Taney's interpretation of the Constitution as it was written at that time, and the origination of the Constitution at that time.
Okay,
I'm not disputing the majority opinion in how they interpreted the Constitution at that time. I'm just arguing that the 14th Amendment ultimately overturned Dred Scott, or at least it was confirmed to be overturned.
In the slaughterhouse cases.
By the 14th in the slaughterhouse cases. So yeah, I'm not disputing the majority opinion necessarily as it was interpreting the Constitution at that time.
Okay, that's cool. I think Taney was brilliant, and I think that he was such a professional because he had an emotional opinion that slavery was horseshit and it needs to go, but he pushed aside his own emotions and he pushed aside his own opinion. And he gave his opinion based off of the facts and based off of the wording and based off of the original intent of the congressional Congress, the people who wrote the Constitution. And he left his own opinion and his own emotions out of it, because if his own emotions and his own opinion would have been injected into that final opinion, which I think around half of the Supreme Court justices were slave owners at that time that opinion was issued. So.
Okay.
I think he's a man of extreme professional attitude who keeps his emotions and his opinions outside of his work, and for that, I think he's an absolutely amazing person and an amazing American, and I think he did a great job as the Chief Justice. And I think the idea that his name was completely destroyed after serving in our fucking Supreme Court for 28 years, dying in the fucking practically in the fucking courtroom. They were giving him whiskey mixed with water at the very, very end in October of '64 because he was so fucked up. He was still fucking working even during that time period. He could barely even fucking walk.
Okay.
He died.
I obviously, you have a very high opinion of Tanny. I mean, okay. I
have a high opinion of Miller too. Miller
I can't
was the
make an
total
argument one
opposite
way or
end
the
of
other. I'm just saying that Tanny, I don't think that Tanny was necessarily incorrect on his interpretation of the Constitution at the time of Dred Scott, but I can say with ease that his interpretation of person and people was ultimately overturned and overruled by virtue of the 14th Amendment and the slaughterhouse cases. Again, that's our fundamental. That seems to be our fundamental disagreement that we're having here.
The words people and persons were not something that was attached to Dred Scott versus Sandford, of which could have been overturned. Those definitions were constitutional definitions. The idea that Dred Scott was overturned has nothing to do with the differences in definitions between the definition of the word people and the definition of the word persons. Well, he says...
Of course it does. The 14th Amendment got rid of that distinction.
No, he's not saying I think or we think. He's saying in the Constitution there are clearly two places where they say the Negro race is a separate class of persons and was not intended to be a part of the original document. He's saying,
and then he later on goes to say that the 14th Amendment got rid of that distinction that was established in Dred Scott.
Okay, fine. But that distinction wasn't established in Dred Scott. It was established in the Constitution.
And then the 14th Amendment
is in the preamble.
And the 14th
and the word
Amendment
persons is in the slave trade clause.
And the 14th Amendment got rid of that distinction. That's what amendments do. That's what
get rid of a constitutional distinction?
Amendments can change the meaning of words.
The definition of the word amendment does not mean we're going to come and slaughter all the Bill of Rights and then we'll give them back to
nobody's saying that the 14th Amendment slaughtered the Bill of Rights. It's saying that it eliminated this distinction that was invented or created by Dred Scott, that was outlined by Dred Scott. That there's no longer this distinction between persons and people.
It did exactly what you said earlier. It raised the blacks originally, but it was meant to be for all non-whites, to try to bring them up to the same level. The intent was really good, but that's not actually what happened because of the incorporation doctrine and because the idea that Congress was given the ability to give which Bill of Rights they wanted to the U.S. citizen class and which ones they didn't, which became the incorporation doctrine. And there's been times throughout the past during that time period where they were like talking about how the original intent was to give the U.S. citizen class all of the Bill of Rights. There's actually cases where they talk about that. And they're like, no, but the court just never really went with that.
But the U.S. citizen, by virtue of the 14th Amendment, did get those Bill of Rights.
No, they didn't.
Yes,
I can prove that.
But they were only protected. But they were only protected by laws passed by Congress, not by the states. Again, that's the slaughterhouse cases.
Check this out. It's in the treatise.
I'm sure it is.
U.S. versus Valentine. It's a great case. Now, this case was from Puerto Rico, which makes perfect sense.
I know.
Right? The only absolute and unqualified right of citizenship
I know.
is to
saw
residents
this too.
within the territorial boundaries of the United States. A citizen cannot be either deported or denied reentry. That's it.
Okay. And therefore,
he's
think
exactly
that,
correct.
Therefore, you think that the Bill of Rights do not apply to U.S. citizens at all.
It applies via
How does that
the
make any
incorporation
fucking
doctrine.
sense?
Via the incorporation doctrine.
Are you telling me that until the incorporation doctrine came about, the Bill of Rights meant nothing?
That's correct.
Okay.
Well, for U.S. citizens.
All right. I think
that's why you and I
think that's it.
Because why would white people give that ability to Congress? You see, it wasn't for white people. It had nothing to do with us. It had nothing to do with people. It only had to do with persons.
persons included white people. I know
No,
you
it
think that
doesn't.
it means. I know.
Absolutely not.
I know.
Absolutely
It
not.
contradicts your entire worldview.
Now, if you want to get really, 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 really technical, if a white guy is in Guam, Puerto Rico, or the District of Columbia, then he would have no choice. He would either
suddenly he becomes a person.
Then he would be a person's class. That's correct.
Gotcha.
But if he
persons is now itself its own class.
Well,
is a person? Well, hold on.
No,
Is a person so a person is a U.S. citizen?
No,
but they're also
they're
also a subclass of a state citizen. That you mentioned earlier.
No, that's okay. So the whole subclass of a state citizen thing, being a resident, that's something that I'm currently looking into and trying to collect more information. So, for example, on that one, I can show you a little bit of what I'm currently collecting on that. That has to do with the whole military occupation and how they forced. So, if you look at like a lot of the state constitutions, you have new constitutions that were coming out around that same time period in almost every single state. And so I started thinking that was kind of weird. So I started looking into it, and it has to do with the military occupation. And basically, in the military occupation, they said that you can't become part of the Union until you do certain things. And inside of those certain things that they were trying to get them to do is really where a lot of that information is located. But I just haven't had time to. That's all brand new. I haven't really gotten into that too much. But I can show you, kind of what I have so far. I can show you what I have, because this is like, I just put this on here like yesterday. So, and it's all connected with, here it is. So, this is an interesting conversation too, because you got to think like, how is the 14th Amendment considered legally ratified when all this shit was going on at that time period, right? So Congress passed the first Reconstruction Act on March 2nd of 1867, which dissolved the existing Southern governments, except in Tennessee, which had already ratified the 14th Amendment and been readmitted into the Union in 1866. And imposed military rule on the remaining 10 former Confederate states, all listed here. These states were divided into 5 military districts, each overseen by a U.S. Army general appointed by the president, which I think was Abraham Lincoln at the time. The military commanders were tasked with maintaining order, protecting the rights of freed men, former slaves, suppressing violence from groups like the Ku Klux Klan, registering eligible voters, including black men, but excluding many former Confederate leaders. That's interesting. And supervising, in quotes, I should put that in quotes. I'm not going to put it in quotes. Elections for state constitutional conventions.
Wait, so now you're disputing the validity of the 14th Amendment?
I'm not the first one to do that at all.
I know you're not the first one. I'm asking if you are.
Well, yeah, of course. I mean, look at this. I'm going to read it to you right now.
All right. So does that apply to the 13th Amendment too?
Well, hold on a second.
15th?
Hold on. Let me read this.
I'm asking you. They were all passed relatively soon from each other.
I know. This military occupation effectively placed the South under federal martial law, with troops enforcing Reconstruction policies amid ongoing resistance, including race riots and political intimidation. The acts specified. Now, keep in mind, the Civil Rights Act was passed around the same time period, again, and the 14th Amendment was also pitched at around the same time period, a little bit after this. So again, the idea that they were trying to they needed protection from the federal government is the stupidest fucking thing I've ever heard in my life. They needed protection from the states, not the feds. The act specified clear conditions for these states to be readmitted into the Union and regain representation in Congress.
But that explains why I think the slaughterhouse cases was bullshit and Miller was an idiot for his position.
Okay.
Because he neutered the 14th Amendment in applying it to the states.
I don't think that's true at all, but anyways, let's continue.
But again, you only need to look at...
We're not going to agree on that.
You only need to look at Jim Crow and Plessy to demonstrate that. But
great. So let's continue with this. Whole constitutional conventions with delegates elected by all adult male citizens, regardless of race, excluding those disqualified for participating in the rebellion. Draft new state constitutions. So this is where we start seeing all these new state constitutions in the southern states that guaranteed universal male suffrage, which means voting for the people who are watching, including for the newly freed Negro. Ratify the 14th Amendment, which they did not want to do. And that's why they had to push out a lot of the Confederate people and make sure all the
Well-
blacks signed up because they did not want to pass that thing at all. They were going fucking nuts.
Yeah, no shit. but
Receive
fuck 'em.
now hold on. Receive congressional approval of the
Thank
new
you.
constitutions by a majority vote in each state. Now, how in the flying fuck could anyone consider under these circumstances that the 14th Amendment was legally ratified by these 10 states? It's just
They
ridiculous.
lost.
It's ridiculous.
Too bad, so sad.
If I put a gun to your fucking head and I say sign here or you die, how is that legal?
Because it was ratified.
I mean, it's presumed to be. Yeah, it's presumed to be.
And it's been established law ever since. Never been overturned. Never been challenged.
It's been challenged.
I know you
many
guys like to do
times.
this with the income tax amendment, but no. I mean, have you ever wondered? Have you ever actually asked yourself why a lot of sovereign ideology revolves itself around the 13th, 14th, 15th amendments?
Have I ever asked myself why? Because that's really where the conversation of what citizenship really is took center stage. Up until that point, even in Dred Scott and Slaughterhouse, the idea of what a citizen was apparently just wasn't much of a concern prior to 1857.
You don't think that there may have been a lost cause, a racial component as to why people have with this ideology have such an issue with these amendments?
I mean, obviously, there are people who have been in. I mean, I guess the better question would be to ask: do you really think that I fit into the typical sovereign citizen mold that you typically see or talk about on your channel? You've even talked about that on your shows about me, that I'm totally unique and different than almost.
I would say
anything you've ever seen in the movement.
your distinctions between person and people and how it's white people versus non-white is something I haven't heard of. But ultimately, at the very end, your interpretation of the 14th Amendment and how it applies to certain groups is bog standard sovereign.
Would you
ideology.
agree that in the grand scheme of what you typically see or think of when you think of a sovereign citizen, or the kind of things you would have on your channel, that I don't fit the typical bill that you would see inside of someone trying to do this kind of stuff?
Well,
mean,
I just told you where I think there are differences. Is that I haven't heard from a lot of people with this ideology talk, at least not today, about this sort of racial component between blacks and non-whites and whites. But I would say that your ultimate classification as to what you can and can't do by virtue of your categorization of who you are, people, persons, citizens, state citizens, that's standard sovereign stuff.
well, a lot of the sovereign stuff, like for years, I was doing the whole state national thing, and I was doing all sorts of stuff, and then I even laughed about it in a show, and I said, and then I started reading case law, and then everything changed. It's kind of goofy, but then I started focusing mainly on a lot of the case law right around that time period, like 1850 through like 1880 is really where I focused for a long time, because that seems to be where the whole idea of citizenship and all this kind of stuff really kind of exploded, and what did it mean, and so I started really looking
post-Civil War,
Yeah.
Reconstruction.
So I started looking into that area very heavily.
I mean, Southerners didn't like the idea of the Negro having the same rights as all of us, and so they want to try and undermine the 14th Amendment in order to say that it was wrongly ratified along with the 13th and 15th. That's why there's the so-called true 13th Amendment, which was supposed to strip anybody with a bar license of their citizenship. I mean, I've heard it all before. I mean, I think you have to think about why a lot of emphasis of the origination of these ideas come from the Civil War and post-Civil War and Reconstruction. But I mean, that's for you to be able to determine yourself with your own research, of course.
Well, obviously, before 57, the idea of citizenship, I mean, most of the cases I've seen, the only aspect of citizenship that anyone's really even talking about is whether corporations can be citizens, and it's always a no. Like John Marshall always said, no, absolutely not. So it just wasn't really a huge confusion, and it's been a confusion ever since slaughterhouse cases to some degree or another. I don't care who you ask. There's a lot of people. Even Clarence Thomas has talked about it. There's always been this confusion. There's entire books written about the slaughterhouse cases and how it fucked everything up. And there's all these different. It's considered the most controversial case that's ever existed, and it's still here. And why has it not been?
I'd say it's pretty consequential. I would say
no, I didn't say controversial. Controversial.
I know. I'm kind of slightly disagreeing. I would say it's a very consequential case.
Of course, it's the basis of
controversy. And I would also
the basis of our entire.
But
it's the basis of our entire immigration system and everything.
I think Plessy was a far more controversial decision.
But yeah, I don't. It's the day after Slaughterhouse in Bradwell v. State, that kind of opened my eyes because he's talking about somebody who's just a state citizen and they're not a U.S. citizen. And it's like, well, wait a second. So someone can be just a state citizen and not a U.S. citizen. The day after Slaughterhouse, he's talking about this. So the thing is that it is possible to have one or the other or both.
Well,
and that's the bottom line.
That's not what it said. But
he said that a person can be a U.S. citizen without being a state citizen. He said that explicitly in Slaughterhouse. So why wouldn't it go the other way around?
Because you're a member of the State of the Union, then obviously you have to be a U.S. citizen.
No. He says in U.S. They say in U.S. versus Cruikshank that a person may be. May. And then the one that you brought up, yeah, the court agreed with the girl who said she's both.
Mm-hmm.
If the plaintiff says they're both,
but you relied on
they're the one bringing the claim.
But you relied on the court's decision in that case, did you not?
Which one?
To the Valdenberg or whatever the hell it's called.
Well, yeah, but the thing is that when he says no white person and blah 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 and all this, it's something he's going off on like a tangent. He's talking like on a more generalized level.
So you think that language where they're saying, of course she's both a U.S. citizen and a state citizen, you think that's like dicta?
If someone goes into a court and says that they are, I've never see the thing that blows my mind about citizenship is that I've seen so many cases where they're talking about it or people are talking about it, and it's just one of those things that like whatever the person says it is almost always what's accepted by pretty much everybody in the court. There's never really like so you think make him prove that or something.
So you think the court there's no weight given to that you want to be given to the court saying yes we agree. Obviously you're both a U.S. citizen and a state citizen. You think that's like a flippant line that shouldn't be given any weight? They
don't do that. They just accept whatever it is that the parties say it is. And like for example with diversity, if one party says that they're this and the other party says that it's not, they determine the diversity jurisdiction based off of what the two parties say they are. They're not saying prove it. They're not saying give me a fucking utility bill and prove that, because I can give you a utility bill for a rental property. How do you know that I'm living there? Even if I give you a fucking utility bill, how do you know?
I think you're trying really hard to get out of that one statement by the court saying that she is both a white lady, was both a state and U.S. citizen.
Well, she's telling them that. That's not.
And they're agreeing with you. Not just agreeing, they're saying obviously. It's as in it should be
because
taken
she's
as
saying
an
it,
obviously, not because she's saying it, because it is.
No. Yeah. If you say something or bring a claim, then yes, fine.
Okay.
There's men going into the court saying they're women, and okay, fine. I mean, there's all sorts of goofiness.
So if in my briefing I go to the court and say, yes, the color of the sky at 12 p.m. was a bright sea green, the court's go like obviously, yeah. duh, as an accepted fact in my legal brief.
If it becomes a stipulated fact, if the other party doesn't object or whatnot, it can be considered a presumption under 301. It can be considered there's rules of evidence. Whatever rules of evidence you're going to be operating off of, there's no objection. Then why would they object to a testifying? If the person signs an affidavit under penalty of perjury, now the other party, if they want to object or fight against that, they would need to provide, in a civil case under 301, they would need to provide evidence to rebut the affidavit. But then if they did do so and the person knew they were lying under oath, now you'd have a perjury charge.
So I would have to prove that the sky was not green on that particular day, or else the court is going to accept it as fact that the sky was a sea green based solely upon what the individual said.
If you have someone testifying on your behalf and the other party cannot destroy their credibility as a witness, and the other party doesn't have a witness, and the one party that has the witness that never has credibility destroyed says certain things like that under oath, and the other party has nothing to really defend against it, then yeah, it becomes a stipulated fact in the case.
I know, but I think we're at an impasse here.
Well, you
So
just
do
said
you-
yourself, getting into a courtroom is going to be new for you, so you'll learn more about the rules of evidence when you get in there. I mean, it's something
I know-
I've been really
I-
heavily involved in.
I've already been in courtrooms before, but yeah, I'm well aware of what the rules of evidence are and laying a foundation and so on and so forth.
Okay.
So all right, it's 7:30 where I'm at, and this is when I usually close up shop on the weekends. But this was
Okay, my
this was
friend. Well,
enlightening.
thank you for
for
coming
sure.
on.
Yeah.
And
Thanks
I think
for
it was cool.
agreeing
I
to
don't
it.
think we freaked out on each other. I think we did a pretty good job of being pretty civil.
I think so too. We didn't no reverse name calling, so that's always a plus.
You know, I don't disagree with a lot of stuff you put on your channel. Just by the way, I think a lot of those people are fucking retarded. So I won't disagree with you.
Yeah.
Frankly,
Hey, you know what? I appreciate that. All right. Well,
I'm gonna stop this thing. Hold on for 1 second. It has to upload. Just give it 2 seconds. So see you guys. Thank you for being at the live. It's gonna be posted, I think, probably on everything. So thanks, guys. See you later. Just give it 1 second. Just give it 1 second here.
We good?
Okay, I think we're all set.
Yeah, we think we're good.
All right, Gene.
All right. Take it easy.
Thank
Have
you,
a good
man.
night.
Bye-bye.
Okay. I want to play some Ghosts of Yote and then go to sleep, drink some water. It went about as what I expected. So, Pants, thank you for the $20. Deacon, thank you for the $10 earlier. Yeah. I mean, I'm not surprised. High Splay, thank you for the 29 months. But my mouth is parched. I wish I had more water. I got more water on here. But yeah, I think I thought I was going to do more of the spooky stream, but that just took it out of me. I'll have to do that. I'll have to say that for tomorrow. Hope, thank you for the $10. I appreciate it. Thanks again. This is the first time I've actually asked someone to ask Guru what their beef is with the 13th through the 15th Amendments. Yeah,
I mean, when he started asking me about whether or not his views line up with the standard like sovereign ideology, that's when I got the idea to ask him the question as to why do you think a lot of these ideologies always like kind of start at taking issue with those amendments, and went from there. Well, I know, yeah, I know. He said that he watched my stream, but I don't think he really had anything to counteract my arguments that I made during that stream. And I think ultimately the fact that he almost ended the stream by not just simply having a separate interpretation of the 14th, but also explicitly disagree with the ratification of the 14th. I think that, yeah, I think we kind of got to the heart of the matter, I think. Okay. I appreciate you guys. I'm going to call it here. Again, play some Yote, do some samurai stuff. I'll be on tomorrow for more of the spooky stuff. And yeah, you guys have a good rest of your evening. Take care of yourselves. Thank you for the likes. Thank you for the subs. Thank you for the donations. Much appreciated. Shut up, Omega. And what time am I going on tomorrow? I'm trying to be more consistent, so probably 7 o'clock tomorrow. 7 o'clock Central. So, all right, guys. Take care. Adios. Have a good night. Bye-bye.
Hi, everybody. What's going on, everybody?
Who is that cat? Archer. You're just gonna stare at me?